This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. The Clarence Thomas hearings were said to have pierced the national consciousness on the issue of sexual harassment. Since then, claims of sexual harassment have reached all the way to the White House. Today we'll look at this issue with our guest, Wayne Outen, an attorney who represents targets of sexual harassment, and Michael Weber, an attorney who represents the employers in these very cases. Hello, Wayne. Hello, Michael.
Hi.
Okay, Wayne, you sue employers that Michael represents. Is that correct?
Absolutely.
Okay, tell us, what is sexual harassment?
Well, sexual harassment has two parts as a matter of law. One is a quid pro quo, and the other is a hostile work environment.
Yeah,
I'm going to explain that. Quid pro quo is Latin for this, for that. And that's the sort of prototypical situation where the boss says to the subordinate, I'll give you sex if you give me sex, I'll give you a raise or a job.
Well, that's an easy one.
It's easy to
understand
the concept.
Right.
It's hard to prove it sometimes because often it comes down to the classic he said, she said.
Okay.
She says he demanded sex for a raise and he denies it, and then you have to try to prove it. The other kind of sexual harassment is called hostile work environment, and that's where there's such a severe or pervasive atmosphere of conduct of a sexual nature that it makes it difficult or impossible for the women typically to continue to work in that environment. It affects their ability to do their jobs.
Well, Michael, what's your point of view on sexual harassment? Do you agree that that's what the grounds are?
Yes, I think Wayne is right in the way he described it. Unfortunately, sexual harassment occurs in the workplace on occasion. I think it's been blown out of proportion of recent days because of some of the publicity that you mentioned before. And I think it doesn't hold the same substance as it once did. In other words, plaintiffs are bringing cases when there really isn't the sexual harassment that used to occur 20 years ago. In fact, I think that there are cases now where the plaintiffs are using sexual harassment to their advantage to either hold on to jobs, to get rid of superiors, or to get monetary settlement.
Okay. Wayne, let's see. You know, everybody out there is either an employer or an employee, for the most part. And if I'm an employee and my employer is calling me names like honey or dear or terms of that nature, which I really don't like, is that sexual harassment?
Just as you've described it, probably not. But it could rise to the level of sexual harassment if the employee has done certain things. If the employee makes it clear that this is unwelcome and unacceptable to her to be called this, and yet the boss persists in doing it despite it being clear that it's not welcome, and it continues and continues, even that level could constitute sexual harassment. But isolated instances at a low level like that generally would not constitute sexual harassment.
Mike, you know, there's an ad that runs on TV, I must have seen it 100 times, with an employer or and an employee, and he says, well, you should be a little sexy in the office, and she says, well, that's sexual harassment. Explain that to me. What can an employer say? What can't? What is unacceptable in the workplace?
If the comments and behavior are pervasive, if some employer said, you look very nice today, that's a very attractive dress you have, that's not sexual harassment. If an employer starts to comment on someone's bodily parts, her breasts, her behind, makes comments about sexual relations on a pervasive, regular basis, that may cross the line. That's when employers get into trouble. But there's nothing wrong in the workplace to have a friendly workplace.
You're gaining weight. You're losing weight. Is that?
I don't believe that's sexual harassment unless an employee says, you know, I'm really offended by that. I think you're commenting adversely because of my sex. Then the employer may be on notice to say, well, maybe I better not continue that type of dialogue.
All right, Wayne, let's say we have this this comment. I mean, what is a person, if a woman or a man feels they're being sexually harassed But they also say, you know, if I bring up anything, if I start waves, I need this job. I'm supporting 2 kids, and I could barely make ends meet as it is. What is the solution for this person? If they make waves, maybe they'll be fired, maybe they'll be demoted, maybe there'll be no acceleration in their job opportunities?
It's a difficult spot. First, as a legal matter, of course, employees should understand that it's against the law to retaliate against an employee for complaining about sexual harassment. And if an employer who does retaliate by firing somebody or taking other adverse action is committing an independent violation of the law in addition to the underlying sexual harassment. Having said that, most employees would rather not get into the situation of having to contend that they were retaliated against as well as harassed. So often employees simply do hold their tongue until it gets bad enough. And in fact, the studies have shown that the vast majority of women or others who are the victims of sexual harassment do not complain unless it gets really severe or pervasive for the very reasons that you described.
Mike, from an employer standpoint, are there, now I know you only represent mostly corporations and employers. Do you have courses for your employees to say, hey, this is what you can do and this is unacceptable?
We have training seminars that we do on a regular basis. Several things employers can do to minimize the risks. Have policies that are clear, which are handed out to all employees. We do not tolerate sexual harassment, and here are some ideas and some things that you absolutely cannot do. Here's who you see. If there are any problems whatsoever, there is a procedure. You go to this person, confidential, complain whatever you want. We put on training programs for managers and employees. We explain what sexual harassment is. We educate them on what they cannot do. We advise them about the risks, about the damages, both personal and financial. Supervisors that are accused of sexual harassment have not only problems with their employer, they have problems with their spouses in their community. I have cases where the individual supervisor defendant is a pillar of his church or his synagogue, and he is very concerned about these allegations. So I try to educate managers that the risks are much higher than, gee, this might have an adverse effect on my next promotion, but it could affect I could be fired, I could be sued personally, I could have a very embarrassing situation with my spouse and in my community. So we try to educate employees, managers on what not to do. We have policies in place for employers, and we do regular seminars to keep people aware of what's going on.
Okay, Wayne, I decided I've been sexually harassed and I'm not going to have this anymore. I go to a lawyer. What happens? I mean, take me through the process.
Well, first thing, you skipped sort of a step that we touched on before, and that is it's important for the employee to make it clear that the conduct is unwelcome. Because if it's welcome, or if the employer may not realize that it's unwelcome, then it may not rise to the level of sexual harassment. And as a practical matter, in real life, rather than running off to a lawyer, most often what the employee should do is to make it clear that the conduct is unacceptable and unwelcome, if possible directly to the person who's causing the problem. If that's not comfortable or not possible, then go, according to the policy that Michael just described, go to whoever within the company, in the Human Resources Department or wherever, and try to...
I've done all that, and this guy's still hitting on me.
Then, that's fine.
I go to the lawyer. What do I expect here?
Well,
do I have to pay you a fortune? Everybody's concerned with legal fees.
Right.
I don't want you as my adversary as well as my employer.
Well, in this area, oftentimes employers who represent employees will work on a contingency or partial contingency
Attorneys
basis.
will work on a contingency. That's important.
Right, or a partial contingency,
So in other
with
words,
some kind of reduced rate.
They only have to pay a legal fee if they get money.
That's what a contingency fee is about, exactly.
Okay.
Right.
And what type of case do I have to have for you to take it on a contingency?
Well, there are two main ingredients of any case that have to be examined. One is liability, and the second is damages. Liability is, have your legal rights been violated? Does the conduct here rise to the level of sexual harassment, as we've outlined it here? And can you prove it? Do you have the evidence? I often tell clients there's a difference between the truth as you know it and the evidence, which is what you can show at trial. Do we have evidence that we can show that there has been sexual harassment? And second, if we can get over that part of it, what are the damages? Have you lost wages and benefits in the past, and do you expect to in the future? What about compensatory damages for emotional distress? Oftentimes the victims of sexual harassment have had a lot of emotional distress, and maybe they've been going to a psychiatrist or psychologist or to their medical doctor with physical symptoms, and or have lost hair, lost weight. So you look at the elements of damages, and together you look at whether or not there's a strong enough case and enough at issue to make it worth a lawsuit.
Mike, what are these cases worth? What do they go for? Give me the range. If this happens, they usually go for this amount. If that happens, they're no case.
Well, it's interesting. There's a recent case that just was affirmed by the Second Circuit Court of Appeals, where 3 individual plaintiffs claimed that the workplace environment was so offensive, literally where their male colleagues were urinating in front of them in the wastebasket. Offensive, awful conduct. Years of litigation. The 3 women got between $10,000 and $40,000 in both compensatory and back pay damages.
Each?
Total. Each one got between 10 and 40. I think the average was 25,000 each. So the damages in that case for the individuals were limited, even though that sounded very offensive. And apparently the jury didn't believe that they were damaged to any great extent, emotionally or financially. There's another component to that Wayne and I haven't touched on, which is the attorney's fees component. That in that particular case, while the individual plaintiffs got very little, their attorneys got an award of $750,000 affirmed by the Second Circuit, because the law in some cases will permit the prevailing party, the party that wins, to get their attorneys' fees paid for in addition to any judgment.
What type of cases are those?
I should tell you that is not a typical case at all on either side. I think the amount of the damages awarded in that case are lower than usual, and the amount of attorney's fees are far higher than usual. I don't think that's a typical case that...
But wait, when does the company have to pay your attorney if you win under sexual harassment?
Well, in any discrimination or harassment case under federal, state, and local law, the prevailing party is entitled to have an award of attorney's fees.
Oh, okay.
And that would apply whether it's sex harassment or sex discrimination or race discrimination. The judge will award attorney's fees based on prevailing market rates for attorneys in the area.
So what is the average? I mean, these cases, what do they normally go for?
It's impossible to say that there's any average, because you have to look at whether it's California, New York, the facts of the case.
Right here, the metropolitan New York area.
It's impossible to give
But
you, but I would tell you, let me give you one. It depends on the salary of the person. But compensatory damages for pain and suffering, I would say the range for sort of garden variety emotional distress would be $10,000 or $25,000.
Okay.
And for serious emotional distress, we're talking $100,000 to maybe $500,000 in a really extreme case. That's the range that has been
Plus all your
in New York.
lost wages.
Plus
and
lost wages in the past up to the time of trial, wages and benefits, back pay we call it, and then if it's projected that wages and benefits will be lost in the future, you can seek some so-called front pay.
Mike, tell me what about if, look, people are in a workplace, they work 8, 10, 12 hours a day. By their physical proximity, relationships start. Whether they're married or they're single, that's what life's about. I read a lot. And but tell me, is that sexual harassment? When does a relationship become a relationship, and when does it become sexual harassment?
Consensual relationship is not prohibited by law. 2 people who choose to go out, to engage in an
Mike,
affair.
I knew that. My mother told me that.
However, when one party says, I'm no longer interested in seeing you. And let's take the typical situation. Manager goes out with subordinate, male manager, subordinate female. And it's not always that way, but that's typically the case. They go out, they have a consensual relationship. And all of a sudden, the female subordinate says, you know what, I'm not interested in seeing you anymore. And he says, no, I want to see you. And he starts persisting. And she says, no, look, I really don't want to. And he starts harassing her. He says, look, if you don't continue our relationship, you know that raise that you're interested in 3 months? That's in jeopardy.
So there has to be the words bringing it into the employee-employer relationship.
Well, it has to be, and that's the context that it is.
It doesn't have to be, it can be implicit.
We're going to a break, but we'll cover that right after the break. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us. Hello, I'm Alan Schnorman, the host of Lawline, and I want to give you some important information about your legal rights. If you were seriously injured in an automobile, a fall down, or construction accident, you may be entitled to a substantial money award for your pain and suffering. It is important to speak to a knowledgeable attorney in that field. At my firm, Solomon & Schnorman, our practice is limited to personal injury law. We fight for the rights of accident victims. Don't try to evaluate the case yourself. If you have any questions about your accident, call us at 1-800-LAWLINE. If you're too injured to come to our office, we will come to you. The consultation is free, and we only get paid when your case is settled or won. Remember, the insurance companies have lawyers protecting their interests, and so should you. Hello, I'm Alan Schnorman, your host. You're watching Lawline. Today we're talking about sexual harassment, show you should watch. With us is Wayne Outen. Wayne represents victims of sexual harassment, and we have A. Michael Weber, who represents the employers. Wayne, right before the break, we started to talk about what level of employee relationships become sexual harassment and what can be said and what not, when they start having social relationships.
Well, as Michael said, consensual relationships are perfectly legal, but most consensual relationships inside or outside the workplace end at some point. And if the subordinate says, I want to end it, and the employer persists, the manager persists in trying to continue the relationship, then at that point it crosses the line and becomes sexual harassment. And it doesn't have to necessarily be explicit that the employer says, if you don't continue this relationship, I'm going to take away that raise. It can be implicit.
Wait, how do you know that? How does a manager or a company know the subtleties of implicit versus explicit? Doesn't the employee have to make it absolutely clear? So there's absolutely no doubt that when you've gone from a consensual relationship, which is obviously intimate, to something that's obviously different. It doesn't have to be absolutely clear to that manager, to that employer, that things have changed. How can it be implicit?
I think you're right that the employee should be make it as clear as possible that the relationship is over. What I was referring to is the conditions that the employer or manager then threatens the employee with. The employer or manager does not have to say, if you don't resume the relationship, I'm going to fire you. That threat that may be implicit by the persistence that the employer has in saying, I want to continue, I want to continue, I want to renew the relationship, and the subordinate should be free to say no and not have that pressure, even if there is no explicit threat made that you're going to be fired if you don't submit.
How do you feel about that, Michael?
I think that, again, I agree that the employee doesn't have to have up a big sign that says, I do not want you to talk to me anymore, but she has to make that absolutely clear. It's okay to say, look, I really want to continue this relationship. I had a good time. We seem to hit it off. We want to continue this. And if she says, well, I'm not, I know, let me think about it, that's not enough. She has to make it absolutely clear. I do not want to see you anymore. Absolute clarity in saying, going from consensual to unwelcome. That's the key word in sexual harassment, unwelcome, in the quid pro quo situation. Is it unwelcome? Are these overtures welcome or unwelcome? Is she leading him on? Is she being less than clear? Implicit is a dangerous word. I want to make sure it's absolutely crystal clear that this employee no longer wants a relationship.
Well, what I don't understand is, in the workplace, especially when you have a manager and an employee, it's not an equal relationship.
That's right.
And if they start dating, even the dating, it may be dating on an equal level and a social level, but still the employee knows he is my manager or she is my manager. Mm-hmm. And is it only when the relationship ends that it becomes a problem for sexual harassment in the workplace, or is there some other avenue?
Well, as long as the relationship is consensual, even though the parties are not equal, it's perfectly legal for it to happen. It's a dangerous situation for the supervisor or the manager in this situation, because if the relationship goes bad, and most of them do, then the manager is vulnerable to a claim that he, typically he, has engaged or is engaging in sexual harassment. So while it's perfectly legal, it's a very, very risky thing to do.
Mike, the employers that you represent, are there any policies where you say, hey, look, if you're going to date, you date outside the company. I don't want you having relationships around here.
Take it one step further. I have clients that have policies that say superiors and subordinates cannot date. It's prohibited because it's bad for morale. There's a question about favoritism. Is this person really getting objective evaluations? How are the other employees feeling when the supervisor is going out with the subordinate? Is she getting better treatment? So some clients actually have policies that prohibit dating between a supervisor and a subordinate.
There are some other companies, though, that say, look, we can't regulate human nature, and so as a reality, we can't prohibit those kind of relationships, even though we would like to. But, and this is a very interesting policy, if somebody is going to have a relationship subordinate to superior, then they've got to disclose it on a confidential basis to somebody who's designated in the company so that we know that it's a consensual relationship and that there's no undue pressure being brought to bear.
Wait, what about some of the claims by co-employees? The reverse sexual harassment claim. I'm not getting ahead in my job because my colleague, Mary, is dating the boss.
Well, as you know, in the Second Circuit, that kind of claim has been rejected by the courts as not stating a valid claim by the disadvantaged coworker.
But there are other courts around the country that will recognize
There are
that.
some in other jurisdictions that have recognized that.
So there are problems then when if you don't have a policy, and I happen to think it's a good policy that say, look, you can't date if you're a subordinate superior relationship. It's prohibited. You can't do it. If you want to ask for a transfer to another department, that's fine. Either one of you. But that's usually good advice.
Wayne,
Sure it is.
have you found that the workplace has truly changed over these last 10 years where sexual harassment has become more and more aware?
Oh, absolutely. There are a couple of cross currents here. Certainly since the Clarence Thomas hearings 5 or 6 years ago, people have become vastly more aware of sexual harassment and the risks that it brings for employers and supervisors and managers. And as a result, you have many, many more companies that have the kinds of training programs that Michael was talking about, and that's terrific. And interestingly, I think that the actual amount of sexual harassment that's happening out there in the world is probably diminishing over the last decade, but the amount of claims have been increasing despite that because of the greater awareness of the wrongfulness of it by employees and the greater willingness to pursue their rights if they have been wronged.
Mike, if one employee or a manager starts speaking to an employee at a lesser level, and he starts talking that, you know, his sexual prowess, and he goes out with all these women, and he's really great in the sack, is that sexual harassment?
No. Unless some employee says, you know, this is really offensive. I mean, I don't want to hear this anymore. That may be
Not my business, it's not my concern.
Well, but it may be the workplace dialogue. It may be that there's a banter that goes on. And it may be both sides. And it may be the women who are the subordinates might say, you know, yeah, well, I had a good time, or we all went out drinking, we did this and that. Now, there are claims for a hostile environment to sexual harassment that Wayne mentioned. And that's an environmental situation, but it has to be pervasive. So
Throughout the whole, in other words, assume these are seamstress or operators, and there's 50 of them, and this one manager...
Not so much the number of individuals, but the behavior of the managers. That has to be pervasive.
Absolutely.
That it has to continue, whether it's with one employee who sits there and hears this over and over again, day after day.
I've had a number of hostile environment cases where the secretary had to listen every day to the boss telling her about his fantasies or his sexual escapades or whatever, and that was all there was. That's sexual harassment because it was unwelcome. She made it clear she didn't want to hear about this, and he persisted, and that crossed the line from being banter to sexual harassment.
Wayne, how do we get over the he said, she said? If it's just one-on-one, and there's no third party, no one ever heard this other than you talking with me, and this was persistent, and I can't take it anymore. How do I prove my case?
That's a problem in many discrimination cases and many harassment cases, and it's a question of proof. And how do you prove it? One, you look for witnesses. Sometimes there are witnesses to these kind of things. Look for documentary support. Generally, that's not present, but oftentimes, I can't tell you how many times I've had women who've come in with napkins from bars that have statements written on there, you know, meet me in room such and such time, or things like that, or promiscuous greeting cards, things like that that provide corroboration for the oral conduct. But sometimes it really does boil down to just he said, she said, and then you have to make choices about credibility. Do the details check out? Does everything check out that your client is telling you so that you can believe that you'll be able to convince a jury that she's to be believed and he's not to be believed?
And I found, as I said earlier, that plaintiffs, some of them, not all, the minority, have concocted stories to their advantage. I have a situation now where a plaintiff claims on the verge of being terminated for safety violations that she was sexually harassed the last 12 months. And as proof of that, she gives a phone number that she says, I got from my boss, who said, call me, we want to go out. And the managers are shocked, and they said, why didn't you bring it up before? Well, my father told me not to complain. So they do an investigation, and they show the supervisor the phone number. He said, yeah, I gave it to her, because she said she wanted to complain about drug use in the workplace, but she was afraid to talk to me because of the employees who are using drugs might see her. So she's now using an innocent, in fact, work-related situation to her benefit, concocting the sexual harassment.
In my experience, that is extremely rare.
Now,
It it can happen. There will always be some people who abuse any system, and I can't say that it never happens, but in my experience, it's exceedingly rare.
Now, I know the two of you are not only experts in sexual harassment in the workplace, but basically all complaints in the workplace. Just out of curiosity for my own self, I just saw California passed a law where marijuana now can be used for medicinal purposes.
Correct.
What happens if an employee is sick and using marijuana, and I'm an employer and I don't want him to use marijuana in my place?
Horrendous law. Horrendous law that's going to be challenged. There are numerous problems about that. And what happens in that? Here's somebody who's under the influence of marijuana is working equipment.
I don't want to work in for me.
Of course not. I think it's a bad idea. It's a bad law. It's being challenged.
But can an employer stop that?
Well, if you have a law and the employee has a right to use marijuana, if there's no risk to the employee or co-employees, the employee may have a claim.
Well, I'm not so sure that's right. I think an employer has the right to regulate conduct on the job during work hours. Some employers do prohibit smoking during work hours and at work.
No question,
Of
I agree
cigarettes,
with
and
that.
I'm sure that they can prohibit smoking marijuana.
What about the employee that says, I need to have marijuana in the morning before I go to work because of some medicinal reason? That employee goes to work and the employee had one joint, two joints, whatever it is. Can that employee then go to the factory, work on a major piece of equipment? Would
Well,
you say
I think
that's okay?
there we get into an analysis under the Americans with
Wait,
Disabilities Act.
let me ask you this. There are other cases here. What about age discrimination? I know you do that.
Sure.
What constitutes age discrimination?
Well, there are federal, state, and local laws that apply to that. Under federal law, any employee who is 40 or over cannot be terminated or otherwise discriminated in their employment because of their age.
Well, how do you prove that?
Well, sometimes you have direct evidence, which is very rare. That is where the employer says, well, you're getting too old for this job.
Right,
I'm
no
gonna
one's
replace
gonna
you."
do it. It's not gonna happen.
Hardly ever happens anymore. So then, like in all discrimination cases, usually you have to rely on
I'm
circumstantial
working here
evidence.
25 years, and now I'm at a high salary. They hire somebody at two-thirds my salary who's 20 years my younger.
Well, the law says that's okay. The law says
right.
you can act for financial, economic reasons.
Right.
Even though it may have the impact of getting rid of the older person who's been there longer, who's making more money.
Right.
In and of itself, that's okay, your example. But it's never that simple. It's usually there's some allegations that there's some ageist comments around, there are people who are making fun of my age, whatever.
Or you look at a pattern, and you see that all the people who are being fired are over 40, and all the people who are being hired are under 40, then you can draw an inference from that it seems like age is infecting this process.
Racial discrimination in the workplace. Tell me about that.
Well, that's the earliest form of prohibited kind of discrimination, and you cannot discriminate in any of the terms and conditions of employment based on a person's
How do
race
you
or national
prove it?
origin.
I know, we know that. Everybody knows that. But how do you prove it is what I want to know.
It's the same thing. You look for direct evidence, which you very seldom ever get, so then you have to look at circumstantial evidence. You look at the patterns and practices of who's being hired and who's being fired. You look at the relative qualifications of the person who got fired and the person who replaced that person, and try to draw inferences from that
Michael,
race
quickly,
is affecting
in the
it.
moment we have left, sexual harassment. If you could rewrite the law, how would you do it?
I think I would put in some risk to plaintiffs, that when they bring frivolous claims, there's some significant damages, including
And
possibly
you heard it
attorney's
here
fees.
on Law Line. Wayne Alton, thank you very much for appearing on Law Line. A. Michael Weber, thank you once more for appearing on Law
Pleasure.
Line. And as always, this is Alan Schnorman, and thank you for watching Law Line.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.